Good evening, everyone. Welcome to the international webinar in terms of the advisory opinion OC-32-25. What does the impact have in Latin America in recognition of the rights of nature in the context of climate emergency? In terms of the advisory opinion in which the Inter-American Court of Human Rights speaks to us about the different obligations in terms of the governments in the continent to protect human rights and, of course, the autonomous, independent right to a healthy environment. We are here thanks to the following sponsors: GARN, an Andean program of human rights, and the different entities that you see here. Welcome to all of you who are here with us from the different parts of Latin America, our region, and obviously other parts of the world that are here with us at this point. I want to remind you that this is the first cycle of the various seminars that we will have today, Wednesday, July 30th, and then the 6th of August and the 13th of August of 2025. Please don't miss out on attending every single one of these seminars. We have presenters of international renowned stature. Tonight, I will be the moderator, and I will be establishing, first of all, the introduction and the presentation of each of the speakers today, and also the rules of the game in which our seminar will take place. Now we will present Natalia Green, who will be the first presenter of this evening. Natalia Green is the Global Director of the Global Alliance for the Rights of Nature, GARN. She's an activist, a politologist, and she is also part of the board of the Defense of Nature and the Environment, CEDENMA. Welcome, Natalia. Next, Agustín Grijalva, also known as professor and faculty member, president of the Center for Rights, CELID PLURAL, lawyer and faculty member, and ex-judge of the Constitutional Court of Ecuador. Welcome, Agustín. Thank you for being here. Next, we also have María Beatriz Eguiguren, who is a presenter. She is the director of the Social and Political Sciences of the Technical Particular University of Loja. She is also a lawyer, and she is also the coordinator of the Observatório of Socio-Environmental Conflicts. Welcome. We also have the presence of Patricia Walinga, who is a woman leader from the Quichua peoples of Sarayaku, who is also an advocate for empowerment of women. And also the 17th of June, she was named as the integrator of the Permanent Peoples for Indigenous Matters of the United Nations. Welcome, Patricia. Thank you so much for gracing us with your presence. Finally, we have the presenter Carlos Mares, who is a faculty member of the Socio-Environmental Unit of the University of Paraná, who's a member of the Center of Pesquisa and Extensão of the Socio-Environmental Directorate. This is an amazing panel, and we have also the representation of CELID PLURAL, who defend rights of the environment, human rights, and socio-environmental justice to present to you this panel that doesn't not only approach the academic aspect, but also the practical matters. CELID will also present their matters in this talk so that you can also follow up on CELID PLURAL and also follow up on the different activities, projects, and next events that CELID PLURAL will organize. With this presentation, without further ado, please go ahead and we will give the floor to the first presentation about the advisory opinion 32-25. What impact does this advisory opinion have? And we are going to start giving the floor to our first speaker, Natalia Green. Welcome. Please go ahead. Well, thank you so much. And Valentina, I'd like to chat a bit and then I'll share the screen. Good evening, everyone. For me, it's a pleasure to be here with you, especially in terms of what we are living currently in Ecuador. It's important to raise our voices to what is happening at an international level in terms of the advisory opinion, that it should matter to us and that we should also talk about. First of all, I would like to tell you that 3 of June of 2025, the Inter-American Court of Human Rights states this advisory opinion. And what does it tell us? It seeks to ensure that there are guarantees of human rights facing the climatic crisis. This is incredibly important. Why is it important? For us, because it's the first time that an international court recognizes the rights of nature. It recognizes nature as a subject of rights, as the Constitution of Ecuador did in 2008. And also, it recognizes the responsibility of the state facing climate change. Well, this responds to more than 150 interventions that were made orally, verbally, and also in a written manner that were presented to the court and now are reflected in an advisory opinion that states human rights, especially regarding the exploitation of critical minerals in order to supply the energetic matters that are taken into consideration in terms of nature's rights and the consequences that mining has in terms of the violation of the rights of nature. The Inter-American Court of Human Rights has recognized the rights of nature, especially because of its need to maintain the ecological processes and to be able to respect the planetary limits and to have an earth for future generations. So let's see how important this advisory opinion is, especially because it states how its essential role regards communities in order to guarantee nature's rights. I think it is key to start with this small summary of the advisory opinion and telling you that as a global movement for the rights of nature, we celebrate with the Inter-American Court of Human Rights that they recognize that it's not a few states, but it's that rights of nature is well recognized and that nature has inherent rights and that this is key in order to gain stability for the planet. And I wanted to state this, and I want to tell you this before going through to my presentation, because I think that we have to celebrate this, especially in a country such as Ecuador that was and is the first one to recognize the rights of nature in its constitution. And that we see now that it's being a very frail process. So if you'll allow me, I'd like to share my screen because I want to tell you how this is frameworked within the global movement of rights of nature. And that is why I thank CELID for having thought about these webinars that are key as Latin Americans, as all the member states that have signed into the Inter-American Court to know about these new tools that are provided by the court itself. I want to start saying that it is celebrated that it's the first international court that recognizes nature and its components as subject of rights. This is said in the advisory opinion OC-32/25, and should be celebrated, and this is framework within this movement that surges as a very powerful movement at a global level that seeks to transform human consciousness, to restructure failed schemes, to live within a framework that deals with harmony with nature and the recognition of the rights of Mother Earth. Why is this so important? Especially because Ecuador in 2008 recognized that nature is a subject of rights, and it was the first country to lead this wonderful movement. It recognizes that nature has an intrinsic nature to its existence, not only to exist, but to maintain its vital cycles, to regenerate integrally. And thank you, Alex, for giving me the word firsthand. And that's why I wanted to introduce that Ecuador has benefited and has inspired more than 40 countries that have advanced in the rights of nature. Right now, there are 22 countries that already have jurisprudence dealing with this matter, and 18 countries that have projects to advance the rights of nature. And please take a look in this small animation that we have here that starts with the Constitution of Ecuador in 2008, and it starts to disperse and to be divulged within the whole of the planet about this wonderful news and recognition that it was about time. Nature has told us in so many ways, so many times, that it was time to recognize it with its inherent rights. And we keep seeing this, and it keeps reproducing itself in the world, thanks to what happened in Ecuador. We have more information if we'd like to take a look. In the Global Alliance for the Rights of Nature webpage, you can find more academic maps that talk about the growth of the advancement of the rights of nature, if it's been locally, if it's been regionally, if it's at a constitutional level, at a national law, if it's an ecosystem. It's worth highlighting that many cases have taken place in favor of very particular ecosystem and in particular river systems, and that has made the system grow. And we have a very powerful tool as well, that it's this eco jurisprudence monitor that allows to see how the cases of nature's rights are rising, not very symmetrically, but having the idea that nature is a subject that has to be protected and not an object that has to be exploited. And this is happening around the world. And I love this map because I see it as a small acupuncture to a planet that is suffering and then it has pain points. That is why we want to highlight some cases. I'm not going to go deeper on this because I know that we don't have much time, but we have amazing cases. We have the city of Quito with the river Machangara that already has rights. We recently had a second hearing. We have found agreements with the municipality so that we can bathe in that wonderful river that right now it's an open sewer. And the mangroves cases representing the sharks in the court and having cases around the world, such in Peru with the River Marañón, presented by the Cocama women, Aruba, that wants to be the second country to change their constitution, Panama, that has a national law to protect rights of nature and that is being implemented and that is being a leader with rights of nature. I wish that it was Ecuador, but now it's Panama. The rivers in Brazil, the River Wanganui in New Zealand, Mar Minor in Spain, Rio Atrato, in Colombia, that are subject of rights. These are cases that we have to highlight and that have been inspired, especially by Ecuador, that has more than 70 cases at a national level in terms of rights of nature. But what is happening? And just want to give you this context. Right now, we have a national alert. The Ministry of the Environment is going to be merged with the Ministry of Mining and is going to be subordinate to extractivist interests. This country that has inspired so much, and even to the topic that unites us today, to the Inter-American Court, it is going backwards in its important steps that it has gone forward. That's why environmentalists want to organize it themselves. We want to have different expressions in rejection of the decree that doesn't have any context, and also a law that just passed that seeks to organize and control the organizations of civil society to shut down the voices of the rights that depend on these voices. We have had press hearing, press release, and the collectives at a social and environmental aspect raise their voices because we cannot allow that a country that is so biodiverse, so marvelous, so avant-garde, that recognized in the Constitution the rights of nature, go backwards, especially in a moment where the Inter-American Court of Human Rights is advancing and recognizing something that Ecuador already did in 2008. That's why it's so important to organize ourselves, but especially that all the people who are listening to us can understand this instrument, that can understand that it has tools in order for civil society in every signatory country in the inter-American system can take cases to the courts and protect nature as a subject of rights. So I want to respect the time I have been given. And I hope that we can keep learning and holding these seminars and spread the message about the cases of rights of nature, because I am sure that we have more people who want to protect life than not. Well, thank you so much, Natalia Green, for your wonderful presentation, also for keeping in time. Also, I want to mention that we have a timekeeping function so that you can know how much time you have. Nature is not is a fountain. It has to flourish and regenerate itself. It's inspired in the Constitution of Ecuador and also the Mother Earth Agreement in Bolivia. Now we will give the floor to Agustin Grijalfa. Please, Professor, you have 10 minutes. Good evening, everyone. It's a joyous occasion to comment about this important advisory opinion of the Inter-American Court of Human Rights. What I'm going to do in the time that I have, I'd like to first of all highlight what is an advisory opinion, which I think can help us understand its pertinence. And also, I want to refer to the main topic about the advisory opinion, but very briefly in terms of its content, that of course it's crucial and of which right now social platforms are generating interesting comments and conversations in terms of a climatic crisis. But what I want to focus on is the objectivity that the Inter-American Court of Human Rights has developed, its focus in developing this advisory opinion. And I think that it introduces a very ecocentric shift. It's a change of paradigm in the way in which the court is understanding the crisis in terms of climate. It's not understanding it under the lens of environmental rights in the conventional sense, but as we will see, it is rethinking it in a different way in terms of the different concepts that have risen in terms of the climatic crisis. So in terms of the first matter, advisory opinion is extremely important. It's so important, such as a sentence coming from the Inter-American Court. Its name can confuse people a little bit. It's not merely an opinion. It's not a criteria. It's not just a sense or feeling. It's an interpretation that is official, and it is obligatory of the American Convention of Human Rights and of other laws and regulation that deal with treaties, protocols, declarations of the Inter-American system. And this is very important because this obligates judges of all countries that are part of the Inter-American system that recognize the Inter-American Court to also interpret things this way. And for what is called the control of conventionalities, also the regulations, laws of these countries have to follow up and adjust and also conform to this obligatory interpretation that the Inter-American Court has made. So this is not a mere declaration. This is a judicial instrument that will allow us and that will help us to litigate in defense of the rights that are established and recognized in the advisory opinion, and within them are the rights of nature, as we will see. They are clearly recognized and expressed in the opinion, as we just saw. So this is the first idea I wanted to share. Second of all, I feel that the topic in terms of climate change, in terms of the climatic crisis, could not be more ad hoc for a reflection of this kind. Because as the court says, it's a crisis that deals not only with and affects not only human rights of all of those who inhabit this planet, but it also affects every shape of life, every ecosystem, every species that is related within the ecosystem. So this is a crisis and a global risk. And that is why this opinion had the most ample calling that the Inter-American Court had in its history, not only for representing different organizations, peoples of the Americas, but also the whole world. And the court received these criteria because it's a phenomenon related to climate crisis that affects the whole of humanity and the whole of the life in the planet, of which, as human beings, as another species, are part of. So this explains why the court, in this opinion, can take this ecocentric shift of which I will speak at this point. And that's the third point I want to make. As a matter of fact, from paragraph 279 and many pages after that, the Inter-American Court explicitly states, affirms, not that others affirm that there are rights of nature. The court directly says that, for example, in this part that I would like to cite, advance to a paradigm that recognizes own rights to ecosystems is fundamental for the protection of its integrity and functionality at a long term, and it provides legal tools that are efficient in terms of the triple planetary crisis. This is not an isolated phrase. It later says that this recognition allows to overcome legal concepts that conceive nature as an object meant to be owned or as a resource to be exploited. Recognizing nature as a subject of rights implies to visibilize its structural role in the vital balance of everything that makes the planet inhabitable. So the court doesn't say what others are saying. So this is the position of the Inter-American Court in terms of this issue. So there is an explicit recognition, specific in section B.1.2. You can check what I'm referencing right now, but I want to make a statement here. Even though there is a section that is more amplified of the previous advisory opinion that referred to the right to a healthy environment, OC 2317, now it has been amplified significantly. The section that is referred to explicitly states the rights of nature, but this reference does not limit itself to this section. This reference is a focus, a paradigm that is cross-cutting all of the advisory opinion. And I'm going to give a couple of arguments in this sense. First of all, let's see the concept of environment that is being developed by this advisory opinion. The concept of environment that is being developed is a concept that is ecocentric, which is completely new, that drives itself away from the anthropocentric that is being dominated by the conventional law systems. So the court understands the environment as a joint element of subjects that are inextricably related that make life possible and for the future. Environment is not the means for human beings in which human beings are the center or the superior species to which people should subordinate in its interests to be also subordinated, the different species and all the planet. No, it's a system of systems of life. It's a joint ecosystem that also the court says that are or have value in and of itself. We can verify this in terms of the sentence or the summary that is in the webpage of the Inter-American Court. But the court is not doing this because they are being spoiled or mere advocacy in a negative sense, because there is an advocacy that is worthy for life and we have to thank it. No, it's not because of that. It's because if it's a coherent component with all of the development that the advisory opinion has. So if we are speaking of a global problem that involves human beings and nature, and if we have so much scientific evidence that is being presented in the introductory section of the advisory opinion, that we can't save the planet without being aware of this relationship, without being aware that we have to value the different cycles, the structures, the functions, existence itself of ecosystems because of their own intrinsic value. Well, this advisory opinion could not be developed. So it seems to me that because of this, in the concept of environment, it clearly develops this shift to the ecocentric scope, and it helps define other concepts in terms of the right to a healthy environment, the concept of environmental damage, the obligations of the state. Everything is described in this ecocentric shift. Really, it's a new conception. I want to end by saying that, of course, I respect the different critical perspective of the rights of nature, but I believe that this advisory opinion invites us to have a serious debate in terms of the rights of nature. The rights of nature are still misinterpreted, misunderstood, as if they were rights of the forest, the river, separating these beings or these natural systems from human beings, and that is absurd. The rights of nature critiques the separation of human beings with nature. We understand nature as systems that are integrated to human beings. What happens is that we cannot see ourselves or perceive ourselves as the center, as the only reason of being, as a superior species, as we say, that should be subordinate or to destruct or instrumentalize as mere property, as an economic resource to the rest of life on the planet. So to wrap up, I want to highlight these aspects. Just one last thought, please. I've seen many discussions in panels on the internet about the advisory opinion on the rights of nature. And in some of them, they don't even mention the rights of nature when the same rights of the same Inter-American Court speaks about a focus. So now we have the challenge to put it into practice. This is a judicial instrument, but it's a fight, the different social organizations, media, Latin American societies that have to give life to this valuable advisory opinion. Thank you so much. Thank you so much to Professor Agustin Grijalva for your important ideas stated at this point. Nature doesn't speak, but it's polluted rivers, and its cut down forests express their opinion. This is exposed in the advisory opinion of the Inter-American Court of Human Rights. Now we give the floor to Maria Beatriz Eguiguren, who will share with us her presentation in 10 minutes. Welcome, Professor. Please go ahead. Thank you so much, Alex. Good evening with everyone. I wanted to thank Agustin and Natalia who gave us a context about this important matter of the webinar that we're holding today. The topic I want to talk to you about is how this advisory opinion of the Inter-American Court of Human Rights is related to the early alert system as a preventive measure for the management of socio-environmental conflicts for the effective protection of the rights of nature. Socio-environmental conflicts are more frequent and they affect people as much as nature, causing violations of human rights and the environment. It is fundamental to count on mechanisms that allow to anticipate these conflicts to prevent them and to mitigate them. In this context, the early alert system is a key tool to monitor and alert about risk situations. Also, the advisory opinion reinforces the importance of these systems for the integral judicial protection of nature and human rights. The advisory opinion approaches the climate emergency and human rights. It explicitly recognizes the importance to implement preventive measures facing climate environmental risks. And in this context, the court mentions that states have the obligation to adopt prevention mechanisms that include early alert systems to identify and respond in a forward manner risk situations and that can affect collective and human rights. Specifically, the advisory opinion says that the duty to prevent needs to recognize brief and effective responses in order to avoid damages in rights of peoples and also that can intervene opportunely. So the court articulates early alert systems as a tool that states have to implement to protect the rights of humans and nature in terms of the climatic crisis and its effects. What is an early alert system? This is an instrument that is based on the systematic recollection of information and its analysis to identify different early alerts that allow to detect risks before they scale to violence or irreversible damages. Its objective is that authorities and social actors can make fast decisions and coordinate themselves in order to mitigate negative impacts. It also links different information and response systems, giving it an integrative and collaborative systems. It is a participative system that has the systematic, quantitative, and qualitative data for high-risk areas. What does this allow? It allows to monitor the deep causes and its engraving factors to understand the anticipated risks of violence and evaluate its urgency, presents strategic options in almost real time for main actors in the decision-making spheres, avoiding the use of violence and promote alternative methods for the pacific resolution of conflicts. What is the cycle that the early alert has? It has 6 phases within its cycle. First, monitor and collect information. This is periodical, taking into account ethnic, socio-environmental indicators, and also variables that are already established, such as governance, environment, socioeconomic conditions. This has to be organized and studied taking into account different sources of information, regional scientific experts, national press. Next step is to analyze and evaluate the information, and this is where all the data is obtained. This information system performs a first analysis. If the analysis shows variations and shows the probable use of violence, we have to activate the early alerts. If there's no agreement, there will have to be a very thorough analysis from experts. The next point is to analyze risk, and this is developed by the team that has to deal with early alert, and also researchers from other universities with which there are agreements on that they can participate in the analysis of the results. The fourth phase is consulting with the community representatives, and here the result of the analysis has to be done in a participative manner with the different actors taken into account, all of the different ethnicities and peoples who live within a community. The fifth phase is to define the options of action, in which the early alert systems develop different scenarios while the crisis is taking place and the different options for action. And lastly, we have the sixth phase, which is decision making. So depending on the different alerts that have been obtained, there will be preventive policies that will be customly implemented for the different actors that are involved, and with the competencies that are established within the regulations and constitution. So this is the cycle or the phase that the early alert has. Based on this, we have the methodology and the key phases that the early alert system that should have combines qualitative and quantitative statistical analysis, local perceptions, and analysis for the evaluation of risk factors. After that, having that methodology in place and the key phases that we have seen, then we will analyze the early alert systems can contribute in terms of the consultative aspects. So there is a recognition about the rights of nature judicial protection within the Inter-American system, prevent and sanction and remediate the consequences on nature and collective rights, the importance of mechanisms of the early alert systems in order to know how it affects rights of nature, the perspectives of environmental matters in conflict management, guarantee of participation in previous consultation. So the advisory opinion represents a fundamental advance for the protection of human rights and nature facing climate emergency because it recognizes climate crisis as a direct threat to essential rights for life, health, water, and a healthy environment. It establishes the different obligations that the states should have, and it also highlights nature as important actor to protect it, and also with the effective participation with previous consultation. What is the integration with the early alert system? It allows to anticipate the negative socio-environmental impacts. It facilitates the articulation between state, social, community actors for opportune responses, promotes the culture of peace and the prevention of violence that branch out from environmental conflicts. It recommends the advisory opinion in local aspects. So it contributes to nature recognized in the advisory opinion. It facilitates a coordination between governments, communities, and organizations to respond to the promotion of participation and response and respect to the rights of nature, ensuring an integral protection. What are the challenges? What has been presented has achieved to identify conflicts with anticipation, strengthening social dialogue, and in some cases, reducing violence. Nevertheless, it implies certain important challenges to ensure. I'll just end with this because it's important to increase the participation of local communities to respect fully collective and environmental rights. Thank you. Thank you very much to Maria Beatriz Eguiguren for this excellent presentation. We're gonna share a phrase. Earth does not belong to man. Man belongs to the earth. It's attributed to a Seattle chief in the Ted Perry movie of 1972. Now we have the presentation of Patricia Walinga. As I mentioned previously, we also congratulate her for being named recently in June as into as being participant of the United Nations of having this wonderful recognition. So Patricia, welcome. You have 10 minutes. Good evening. Thank you so much for your invitation and also for your congratulations. I am the first Amazonian woman who's in the permanent forum. I'd like to speak about the advisory opinion that the Inter-American Court of Human Rights has made. After having many opinions and perceptions of the civil society, among them the indigenous people, we were last year in Manaus speaking about our own perspective about this climate crisis, because this is not only climate change, it's a climate crisis. And I'm satisfied to see that the advisory opinion mentions the Amazon region as such a vital, important system because it regulates climate in terms of evapotranspiration. Because I am Amazonic, this part should not be left out. The ecosystem in the Amazon within the advisory opinion of the Inter-American Court emphasizes the importance that it has for humanity, this bio-Amazonic sense. Seeing this analysis of the Amazonian biome, whenever it refers to the Amazonian peoples, this science that studies all of this crisis, that sees what's going on, science and ancestral knowledge of society at a local level of indigenous people who that inhabit these regions. It places a special emphasis in how it has to be protected, how it has to be incorporated, how they have to be valued within this advisory opinion. It mentions that governments have to value and protect this knowledge that is so vital in the fight against this climate crisis. So I feel that this is really important to mention because it implies that states have to take the necessary measures to protect, to strengthen what the Inter-American Court is mentioning within its advisory opinion. And this happens because of the rights of indigenous peoples, the collective rights. And this is also happening because in the territories such as the Amazon region, without listening to what is going on, there are new frontiers that extractive frontiers that are being opened. So it's necessary to keep mentioning that local knowledge, indigenous knowledge, as the court is mentioning, are intertwined with the climate crisis and with all of the changes that are happening at the moment. So that is why importance that this court mentions directly the knowledge of indigenous peoples, the rights upon these ecosystems. Many might say that this is just an advisory opinion for us that have been fighting for so many years, talking about the rights of nature, talking about the importance of incorporating them into our daily lives. Whenever we have spoken before the court of how important it is to link the rights of nature, and that right now there is an advisory opinion that is coming out allows us to have tools that can be used in many parts of the region. And that these tools that might be used have to favor nature, but also human beings that inhabit this nature. Because us as indigenous people see ourselves as one with nature. We don't see as the center of nature. We see ourselves as one. If we destroy this vital space, it's the self-destruction of indigenous people. If we discuss this at a legal level, such as what the advisory opinion did with the Inter-American Court of Human Rights, it is fundamental that these advisory opinions should come out more. I know that this is one of them. I know that there's another one that will or might come out from The Hague that will reinforce this vision and this paradigm to be closer to nature, that we feel part of it, not with an extractivist vision, not as a perspective of placing the economic model on top of rights of nature and rights of people, but something that comes to generate balance of such a palpable crisis within our social context and within our countries. I feel that it is also important to mention that this advisory opinion, if we start to analyze it, we can overcome judicial conceptions that have been putting nature aside. And I feel that the court mentioning in this way is so important. It allows us to see further on, more than what human rights could be, or something that is isolated, but the incorporation of the rights of nature allows us to open a new path within the different concepts that we have and allows us to have a much closer debate or discussion with indigenous knowledge. We have participated in different spaces where we have discussed the importance of the rights of nature, and we are always prioritizing of nature. And obviously, this vision is not amicable with extractivism. It is not friendly with oil extractivism. It's not friendly with lumbering and anything that implies destruction. Whenever I am asked if this has to be stopped, I feel that within this point that we are at a tipping point, that the same court mentions that there is a point of no return. It is important to regulate and ex exclude these spaces that are so vital to humanity and that regulate climatic environment. I know that I have a few minutes left, but I feel that I expressed many things, but I know that I can speak about many things, but I think that science is approaching the knowledge of ancestral peoples. And if this allows us to generate new ways of protecting different spaces, we will have taken a very big leap forward. And right now that we are facing this point without finding the adequate solutions in order to face a crisis that is so real, so palpable within our context. Thank you. Thank you very much, Patricia, for this important presentation. And obviously with this enriching focus, my soul sees nature, and a poem by Gabriela Mistral. And to close this series of presentations, we welcome Carlos Mares from Brazil. Welcome, Professor. Go ahead. Thank you. Good evening. I believe that the advisory opinion of the Inter-American Court of Human Rights 32-25 is a very elevated point in the discussion of modern legal matters. But we have to understand that this is a judicial subject. And many times the judicial matters, in order to impose themselves, has political considerations that in the world there is a very significant political dispute in terms of the future. That is why the judicial instrument that we have and that has alerted us, the Inter-American Court, is very important. I want to talk about 3 points. The first one is that the court doesn't make rights, it doesn't make laws, it interprets them. And this document of the court is so important because it interprets that in the judicial, national, Latin American, or American systems at an international level, worldwide, there are enough judicial convictions to say that the system recognizes nature as a subject of rights. Therefore, it's not the court that says so, it interprets what is being said. And of course, this interpretation is clearly coming from a joint of judicial regulations that are recognized within the system. Yes, there's Ecuador, there's a Mother Earth agreement in Bolivia, but there are many other international regulations, such as different examples from biodiversity and many others. Therefore, what the court is offering us is the possibility that we can have the discussion of subject of rights in laws that already exist. Therefore, it hasn't been created. The second point that I want to make is that the modern judicial system is a problem. I usually say that there's an insufficiency of the judicial system because, of course, well, coming from us, from human beings, nature has rights. Of course it does. I think that very few people would say that it doesn't. But why doesn't it have it? What are rights? The modern judicial system bets on nature outside of rights. But the fact of leaving it on the outside as being an object doesn't exclude the reality that nature has rights to exist, to live, of being in its territory, of having all of its interactions with humanity as well. Therefore, the issue is that right recognizes rights whenever it is written in the law. When a law says that a right is a right becomes a right. So, what the Inter-American Court of Human Rights is saying in the international judicial system can analyze the concrete existence of laws that recognize the rights of nature and nature as a subject of rights. I'd like to show 2 examples of rights that are rights, obviously, but were only recognized by the modern capitalist judicial system after they were written in the law. And even after being written in the law, they're very difficult to apply. So I would like to show 2, and I hope that it depicts what I'm trying to say. First of all, it's the rights of peoples, collective rights. Collective rights of people to be able to live in community, in conviviality, territorially, and in their common living. Of course, that's right. These peoples have to resist, but it was always negated in the modern capitalist system of rights. And it's been introduced again or it has been introduced in the late 21st century, not only in Latin American laws, but also international laws. So right now, we don't doubt in the 21st century that peoples collectives, communities have rights. The second right that I wanted to tell you about was the right to have access to food. Nobody can say that somebody doesn't have a right to feed themselves. But the right to feed yourself is recognized within law as a right next to the rights of human beings, but it was merely introduced in the 90s. Therefore, the modern capitalist system had negated during all of this time the existence of a right to be able to feed themselves. I could talk about many others, but I will just keep these two because these two rights that are recognized as essential parts of human rights are not human rights. The collective rights of peoples, of cultures, of existence, of integration, as well as the right to access and eat food belong to nature. It's not that just human beings have the right to have food. This is a right that all living beings should have because they need this to live. So, the construction of the subjective rights of the Inter-American Court goes through the interpretation that these human rights are not only human, these rights also belong to nature. And the third point that I would like to make is that the judicial consequence of the recognition of the rights of nature and nature having rights is very profound, and that it's not possible to maintain this judicial system as we have it today, as it is in the different civil codes, but also in the different constitutions, and also the role that the human rights have. If we recognize nature as a subject of rights, the moment we recognize nature as a subject of rights, we have a contradiction, a problem that cannot be solved with words, but it has to be resolved with deep tissue changes in the judicial system. And in my point of view, the deepest change that has to take place is of private property of land. Private property of land is an invention of the modern judicial system. It was invented in the beginning of the 19th century in the civil codes, and the land started to be called a judicial asset, uh, um, like real estate. It lost the name of land, it lost the name of nature, and it became a judicial patrimony of just one person. Such a power within the civil code that can destroy nature. It's not possible to keep this private view of land in tune with the rights of nature. So the judicial subject, which is nature, imposes a destitution of the individual right to land. Land should serve its purpose to every person involved. This is the most difficult conundrum that we have. Just to close my presentation, I'd like to say that the recognition of nature as a subject of rights is so profound, as has been negating slavery in the 19th century, which is a right that guaranteed the freedom of all, had to recognize that those enslaved also had individual, personal, human rights to freedom was the application of a judicial system that already existed, but it wasn't the correct one. The same thing happens now. Whenever we talk about the subject of rights, which is nature, we are accepting something that is already within the system, but also negates something else in terms of the private property of land. Thank you. Thank you so much to Professor Carlos Mares for his brilliant presentation. Now we will mention a small phrase. Because we didn't inherit the land of our ancestors, we take it from our children. This is an indigenous proverb that is cited in many works. In this moment, we're gonna take a small break to prepare for the second part, which will also be interesting in terms of the questions that our presenters will answer. I just want to remind you that we have many organizers that are seen here, CELID, PLURAL, the Observatório, CEPEDIS, GARN, Universidad Andina Simón Bolívar, and the Red Jurídica Crítica, CEDI, PLURAL, starts with a series that will take place during 3 weeks. Another way to reach our audience in order to have debates, discussions in current topics. We are committed to the defense of rights of humans, rights of nature, cultural heritage, and environmental justice. All of this from a plural, intersectional, critical, and sustainable perspective. I also want to announce, because I've been asked from the Human Rights Program, there are 2 programs that are open now. We are placing 2 links so that you can access the information for public policies and also for crisis context. You can also delve deeper on these subject matters. We also have a specialist program for rights, human rights, and also a program that deals with rights of human rights and restorative youth rights. Now we are going to have our second part, and our presenters will have between 5 and 10 minutes to answer questions. We are going to start with Natalia Green, and I will read the question. Which do you consider is the importance and impact that the advisor opinion will have for the rights of nature, and in particular for civil society organizations, considering their growth during the last years? And also, what could these challenges, opportunities, and risks entail? Please go ahead, Natalia. Alex, thank you so much. And I'd like to thank all the presenters about this important matter. I think that it's important to highlight that this is a historical moment. The fact that the Inter-American Court of Human Rights is explicit about rights of nature. I want to highlight what Patricia is saying in that sense, that science, laws are reaching out to what ancestral peoples have been saying. It's so important for this to be translated in the understanding that we are nature. In legislative aspects is so important. That's why it's important for the movement of the rights of nature, as I have exposed, has grown exponentially. And it's important to give you a few data. Antonio Gutierrez said that the movement of eco-jurisprudence was the movement of more growth in the 21st century. There are also important growth in terms of the academic material and data about the subject matter. It's important to highlight that whenever we stated this for the Constitution of 2008, we used to find 4, 5, 7 articles written about the subject matter. And now in Google Scholar, you can write rights of nature, and there are more than 18,000 entries. And it's amazing to see how this has grown, and it's been very different in each country, in each one of the regions. And for me, it's so important to find the system, or the crack in the system, to be able to introduce such an important topic, because we know that our systems are always controlled by governments and companies that look to feed their ambitions in order to exploit them, to keep having income at nature's expense. If we don't change this paradigm, or if we don't see ourselves as part of nature, there is no planet two. There's no planet B, not for only future generations, but the same one that is here right now. So, what is the impact? I think that civil society of all these signatory states of the inter-American systems have jurisprudence, have international jurisprudence. I feel that this is the most important aspect. And we've seen a debate that deals as in the scope of what it reaches, right? So this is like a metaphor in the sense that we have been able to change all of constitutions, yet not as broadly as we see it in Ecuador. And there are going to be states and courts that are still debating this, but it's there. It's being talked about. If it can be used as jurisprudence at an international level or not, there's a court that has established this advisory opinion. As Agustin is saying, this is a judicial tool and there is jurisprudence. So this allows civil society organizations to say, we're not crazy. I'm not saying that I'm a river. The river has rights. I am the river. We are part of this. And we can state a case of violation of the rights of nature for a river, for an ecosystem. We can amplify this vision that nature can reach the courts because there is international jurisprudence. What are the challenges? That we are still in a transition, a model that sees nature as an object, and we have to transition from this anthropocentric view to an ecocentric view to understand that nature is subject of rights. And there will be courts and judges and lawyers and people. If there are two lawyers in the room, there are three opinions in the room, many opinions that say if this can be used or not. My call is that civil society at a Latin American level, of all the signatory states of the inter-American system, can use this jurisprudence, that we can go to the courts, that we can state these cases, because in even countries that didn't have this tool, such as Peru, that's why I mentioned the case of the women in Cucama and the river Marañón. A country like Peru that doesn't have jurisprudence in terms of rights of nature was able to achieve that a judge can recognize the rights of the river Marañón. So we don't only have to cite comparative jurisprudence of Panama, of the national law of Panama, of the Constitution of Ecuador or Bolivia, but we can cite an advisory opinion where the signatory countries have to fulfill it, in the sense that it is a binding advisory opinion. I think this is key. I think this is a really big challenge. There are people who still reject it and that still questions it. Why? Because there are financial interests that are pretty strong that will not favor nature having rights. And I remember hearing this, and it is important to already have a declaration of nature's rights. It's important to have this advisory opinion. If we have setbacks, if we have violations, if we have Ecuador with a constitution that has it in place, supposedly, but we're not questioning that the Declaration of Human Rights exists or not. We're really happy and content that 77 years ago there was a Universal Declaration of Human Rights, even though today these rights are being violated. And we know that this is a reality. Nevertheless, we keep implementing and seeking that these rights are exercised. So please don't be more demoralized. There are states that may not want to guarantee the rights of nature, but this doesn't mean they don't work. It means that we have to fight stronger in order to achieve them. Thank you, Natalia. We're gonna give the word to Agustín Grijalva. Also, if we could show the question. In the meanwhile, I'll keep reading here. Question for Agustín Grijalva is the following. The advisory opinion states that the rights of nature and the right to a healthy environment have to complement each other. Do you think this is possible? And if it's possible, is it desirable? Can you hear me? This is a debate that has been taking place for many years. Because from environmental right or law, there are skeptics or people who don't recognize the rights of nature. They have their argument. They say it's not practical, that it negates human rights from the rights of nature. The right to environmental rights is just regulated in terms to measure environmental damage without protecting ecosystems very well, to legitimize or justify the exploitation of nature more than its protection. But I'd say that this advisory opinion places us in a position to debate. And I feel that the moment has come for international environmental rights in terms of an advisory opinion to take this debate seriously. I've heard brilliant panels in terms of climate change during these days. They've been very enlightening, but have negated the rights of nature. And I feel that this cannot be done. The vision, the focus of the advisory opinion is in the center. So, as it was said, is a process that was taking place since from before in 2017, the Agreement for Biological Diversity. There are dozens of declarations from the United Nations about rights of nature. Also, there are sentences, as Natalia was reminding us, in many countries of the world. And there's this advisory opinion from an international court. So the topic is on the table. I feel that the reconceptualizing of what is understood by environment is important because the court is saying the following. They're saying the conditions for human rights, including the right to the environment and the right to a healthy environment, which is the right to which a healthy environment is alluding to, says that these human rights need as a condition the rights of nature. That's what is being said in the pertaining section. That's a relationship that is being established. So this is a completely new concept, as Professor Mares is saying. Human rights have to be rethought, and they are being rethought. There's a group of political philosophers. They're talking about this in many parts of the world. The fundamentals of the rights of human rights are reconceptualizing because this is a new way to conceive human rights that makes us think about the rights of nature. The advisory opinion says the rights of nature surge from the relation between human beings and nature. Therefore, there is no sense to say that rights of nature forget the human rights. These rights come from the relationship that we have. It's us that are being aware as part of nature that we have to respect cycles, structures, the existence of ecosystems of which we are part of. So, undoubtedly, this has to have, it cannot have an impact on the right to a healthy environment, the sense of having a healthy environment. How does a court conceive a healthy environment? How does a complex ecological system integrated by other ecosystems that work jointly as a planetary system that work adequately with other ecosystems? This is a very ecocentric viewpoint. And the idea of the environment as a means for human beings who are the superior being, the dominant being that converts everything into instruments, into something utilitarian, is overcome in this advisory opinion. So I feel that there is a shift, a deep shift with epistemological consequences, technical consequences, and that have to be landed to the legal aspects and, of course, the social struggle. Thank you, Professor Agustin Grijalva. Thank you for respecting the time. At this point, we will go to our third question in the order that we had previously defined. Here is a question. Taking into account the high conflicted nature of socio-environmental issues in Latin America, do you feel that this new advisory opinion provides new concepts and mechanisms to better improve the protection of nature oriented to respond to crisis during the climate crisis? Sorry. I consider that the consultative opinion offers important answers to approach this situation that Latin America is going through, especially where the economic interests, the defense of the territories, extractive situations are still generating migrations, violations of rights. And with this advisory opinion, the court not only gives legal tools to communities in the social movement in order for them to defend their territories in terms of the different projects that exist, but they also strengthen the framework of protection for these private or state actions that can have a consequence in civil unrest and different violations. So I think that there should be consultations to avoid conflicts, especially to bring protection to vulnerable groups and defending the social cohesion in terms of the escalating environmental conflicts that exists. So these are scenarios where there are more violent conflicts for the use of natural resources, the access to water, land, and other resources, as well against earth defenders. And also, this implies the protection of those who lead the environmental defense. So I feel that the advisory opinion does not only provide concepts, but it also establishes legal mechanisms that are concrete to be able to face environmental conflicts, becoming a feasible tool that can prevent and restore different elements of the climate crisis and the recurrent socio-environmental conflicts that Latin America is facing at the moment related to the subject matter. Thank you very much, Professor Maria Beatriz de Giguren, for your concrete answer. At this point, we will give the floor to Patricia Walinga, who is being asked the following question. I will read the question for Patricia Walinga. In terms of the consultation opinion, I think that the consulting opinion responds to the socio-environmental crisis that indigenous peoples have at the moment, because it says that nature is not only an object of exploitation, but there's also a discussion of it having rights. So there are countries like Ecuador that recognize the rights of nature. And this concept does not delve deeper on all of the conflicts. It does mention certain risks that exist, especially within territories such as the Amazon, that shift the ecosystem, that the Amazon that is humid is drying up, and that we're in a point of no return. It mentions it very clearly. And it also mentions how much carbon the Amazon is sequestering. With the destruction of the Amazon, it would not be favorable for the rest of the planet. So it mentions very clearly the Amazonian theme, but it values at a scientific knowledge, the knowledge of indigenous peoples as well. It speaks about protection, that the protection that this knowledge should have. And it mentions that those who are in the first lines, the front lines, are being wronged in different senses because of the crisis that we are going through. It speaks about floods, it speaks about lumbering. So it is pointing out explicitly the causes that are contributing to this crisis within indigenous peoples. I want to go back to the topic I mentioned, and it mentions clearly about the value of knowledge and how this has to be applied in order to work diligently, and how this has to be protected by the states. It shouldn't be appropriated for commercial benefits. It should be coordinated in order to reach a solution. I think it has to be very specific. It has to be extremely clear. Uh, According to the reality of the indigenous peoples, it talks about the approach of ecosystems in the Amazon. What impact do indigenous people live through? What crises are being gone through people who live on the shores of Amazon rivers? And at the same time, what is the chance to coordinate with science? And I do feel that it approaches it because they listened to the indigenous peoples in Manaus, where we had the hearing. There were dozens of indigenous peoples who went to testify in terms of the advisory opinion, what was going on with the lumber companies, with mining companies, with highways. In gathering all of this, I think it has stated it within the advisory opinion, something that for the court is not new, because they had already sentenced cases such as the Sarayaku case, where in one way or another, it visibilized the impacts that the extractivist activity could have. And even though it favored human rights, it had to deal very much with ancestral knowledge and the rights of nature. So it does gather in a detailed manner, and it doesn't treat nature as an object, but it's a subject of rights. Would mention here, just to make a point about speaking about proposals that the indigenous peoples have. Sarayaku has the Selva Viviente proposal. For us, nature always had rights. It was always there, and the forest is a real recognition that nature is a conscious being and it should be a subject of rights. It has to be free from extractivism. It has to exclude in perpetuity any oil extraction. And this doesn't have to be in the hands of the governments because they privatize protected areas, but it has to be in the hands of indigenous peoples who have been the custodians of this area. Thank you. Thank you, Patricia Walinga, for your wonderful answer. And now we will go with Professor Carlos Mares. I want to check the question for the professor. Do you believe that the recognition of nature as a subject of rights constitutes a structural rupture in modern law? How do you visualize this in terms of the advisory opinion? Well, thank you. I believe that this is a rupture of a paradigm. I believe that in the 20th century, whenever the collective rights of peoples were recognized, it was the first rupture of the paradigm. Now, with the recognition of nature as a subject of rights, it's a final rupture. Why do I say this? Because it's not possible to recognize a judicial system based in individual property rights fundamentally, which legitimacy is being given by a contract, which is something that define mutual obligations, equal mutual obligations, but they're not really equal. They cannot generate a legitimacy against rights of nature. So the judicial system, the modern judicial system, which is capitalist, colonial, that has been created, that has been developed, in the 4 or 5 centuries of colonialism and had been developed uh, in an accelerated manner in these 2 last centuries by way of the civil codes and the constitutional systems. The system is a human and individualistic system. Anything that is not human and is not individualistic is outside of the system. Whenever we recognize collective rights, nature as a subject of rights, this system loses its fundamental basis, which is individual private property. But from all of the properties, material properties, in the simple sense, things, can even outlive based on the contract. And why am I saying they could? With little changes, it can be fixed. The difference is that whenever merchandise is taken into account as a private property, it excludes others. It can subsist, but properties in terms of the invention of capitalism, things that capitalism has transformed into merchandise because of legal rights, which are land, which is the most important of all, knowledge, with different copyrights, patents, excluding other types of knowledge, and also more recently, seeds. So it's impossible for a system that can organize and give rights to the earth, to knowledge, and to seeds can subsist with collective rights that are non-contractual because they are rights based on respect, based on needs, based in love. that cannot subsist as an exclusive contractual system. So, if we ask ourselves, is it possible to recognize nature as a subject of rights and at the same time saying that seeds are the property of a particular person that are used to not only produce food but to produce earnings? Can these two systems coexist? Of course not. So we are facing a deep transformation, not only in terms of rights, but also in terms of society. It's necessary to have both in order to work properly. Of course, I agree that these legal norms can be used that give nature the status of subject of rights to allow other changes in society. It will be the main source of change. So we are facing a deep transformation, and there are ways to resist. People still resist because people still resist for the existence of peoples. Thank you, Professor Carlos Mares, for your presentation. At this point, I will thank the different organizations that sponsor this event. There has been a network that has been formed that we hope in the future can hold these types of collaborations. CELID, PLURAL, CEPEDIS, GARN, the Andean Program for Human Rights, Universidad Andina Simón Bolívar, REDIJC, and also CELID that has given us the opportunity to organize this event. I would also like to reference the Andean Project of Human Rights that at this point is promoting the public policy tools for support in current times of crisis and also youth human rights. And just to close, also thanking each one of our presenters and also repeating what I have here on my notes. Just to brief, just brief words of the importance of what has been shared by our presenters. From Natalia Green, we have talked about very important backgrounds of the origins of rights of nature with its origin in Ecuador, what is nominated from Marcelo Neves is transnationalization of rights. Now from the South, we are also exporting these new ways of thinking and rethinking, as Carlos Mares was stating, from a non-traditional position, non-ethnocentric. And this is also important because the rights of nature are present in many countries of the world. Also from Agustin Grijalva, there has been a thorough explanation about the advisory opinion saying that they don't have the character being interpreted. There's a lot of debate. Are they binding or are they not binding? So whenever you check the Vienna Agreement of 1969, sticks to what international law says about soft law, they are non-binding, but the development of the Inter-American Court of Human Rights in many of its stages have shown us it's binding because they're an interpretation of the contents of the opinion, and while they might not be respected, it may be that one of the states can not observe them thoroughly and they can have consequences. Moreover, if they have been part, as it has been shown by the Inter-American Court of Human Rights, part of its sentences, and also the Ecuadorian Constitution. So it's also important to point out of what has been mentioned, these jurisprudences already have an ecocentric focus with which we are giving intrinsic value in and of itself of these nature elements. Then we also had by Professor Beatriz She spoke about the different cycles for prevention, early alert systems, the different 6 stages of a cycle of the moment of monitoring, collecting data, organizing these different risks, and also how the the advisory opinion has given protection in terms of the current climate crisis. Many people think that the climate crisis is merely something that's being discussed whenever we see palpable effects. Many countries that belong to the United Nations, they're joining their voices in the different conferences dealing with environment because of the real life situations that are happening in terms of climate change. So it's giving us important elements to front the climate crisis and the obligations that every state has in order to prevent the damage of ecosystems. And also an important analysis, an important focus. It is Transcendental by Patricia Bolinga that speaks from where she speaks to us from the Amazon, where the ancestral knowledge of the different indigenous peoples are being rescued, are being recognized. And this is a very important scope, and Patricia reminded me in Carlos Bolmer from Brazil, who speaks about the critical thought and the ways of fighting against positivism. He talks about the combat positivism, how to revalue the knowledge of the peoples of the South and taking them to the legal sphere, whether it be in internal courts or international courts. And also, it's important to point out that this recognition that is being given calls to the reflection to seek for new paradigms. And I was thinking about the historical questionings or doubts that we sometimes forget. Nature was already considered as an animate, transcendental element. Socrates, Plutarch also talked about this, that placed a very real importance to nature. Something that was mentioned by Carlos Mares whenever it was pertaining to rationality with Descartes and Bacon. They reset us and we separate nature from the human being whenever a human being has always been a part of this whole ecosystem. And finally, the judicial complexity, what Carlos Mares is saying in terms of a series of disputes for the future. Is it or is it not a subject of rights? And it calls to our attention how lawyers don't call to our attention that a corporation or a judicial company is subject of rights. For us, it's clear, it's evident that something is a subject of rights, but a river, animals have rights whenever they have a life of their own, intrinsic value. That right along history has recognized that certain people or certain groups have rights or not. Speaking about rights to food. They're linked to human rights, and that's why the exercise of these rights is very important, that they're linked to human rights as much as human nature rights. One of the biggest challenges is to transform these concepts and these traditional perspectives have been given from the global north to have different positions because climate change is a reality and it's not a future threat. And I allowed myself to give a very small, succinct summary. I'd like to thank each and one of the presenters for their time. Not only for you, because each and one of you within your own spheres have worked and have been working as activists, as researchers to contribute that this world is better, especially in the struggle for the rights of nature. You are the voice, you walk the walk and talk the talk. So it's great to see you. See you next week. Thank you. Good evening.